SB 294. This is a law that is going to require all employers to give a written notice to employees regarding their rights. So Carter's going to talk a little bit about, the typical labor law posters that, we all use in the workplace. This law goes a little beyond that and says that now there actually has to be written notice given to employees, including new hires. And we'll talk about what that's going to look like and what you're going to have to be prepared to start doing effective January 1. So this is known as the Workplace Know Your Rights Act. So you may hear that referenced out there in the media. And basically, as I said at the outset, this applies to all employers. So we all know that there's some laws that apply if you've got 50 or more employees, or there's some laws that apply if you have 5 or more employees. This one applies to everyone. And what this law says is that a standalone written notice must be given to all employees each year effective January 1st, 2026. And I really want to emphasize standalone, right? This is not something that we can just rely on the labor law posting to meet the obligation for. We need to actually have a standalone document that is provided to employees. Now, the notice can be emailed or texted even if that is a method of communication that you typically use when you're communicating with employees. I'm going to give you one watch out though, okay? That is, when it comes to texting, you need to be very cautious that you are not texting business-related information to employees on their personal cell phones. Because if you do, that gives the employee the ability to claim that their personal phone was being used for business purposes, and therefore I am entitled to reimbursement from the employer for a portion of the cell phone costs. So if you've got employees that have phones issued by the employer, no problem. But just be very careful, just in general, not just with these notices. And we're in a world now where texting seems to be the most common and efficient way to communicate. So a lot of people, employees included, are dependent on texting. Just be cautious. You don't want to, for instance, text people direction about how they're supposed to perform their job on their personal phones, because now it's a business use and you got to reimburse them for it. Okay? So, it could be electronic, but, doing a piece of paper, analog in a digital world, that also works. So we'll talk about what that's going to look like. And as I mentioned, it must be provided to employees upon hire. So it's got to be another thing that you put in your hiring packet, right? All right. So there is going to be a template notice developed by the Labor Commissioner. I'm smiling here. On or before January 1st, 2026. It's going to be like the bullet train, all right? It's going to. I have my doubts, and we've experienced this a couple of times where they pass these laws and say, "Oh, the Labor Commissioner is going to develop it," and it doesn't happen on time. So, my point is that yes, keep your eyes open for that template because it will be a useful thing to use, but don't depend on it coming out by January 1st because it would not surprise me. And even if the template doesn't come out, you still have to comply, okay? But I just wanted to highlight that there is a template that is going to be coming out. All right, so what is this notice going to look like? It has to advise employees of certain rights. And let me just go through these bullet points. The first, it has to advise employees of their right to workers' compensation benefits and the contact information for the Division of Workers' Compensation, which to me is really silly because already the Labor Code 2810.5 form requires you to give workers' compensation information to employees. But, hey, I'm not in the legislature, so they thought, no, we need to include that in there. So that is one aspect of what needs to be included on the notice. The second, and this is really what this law was designed to do, is to give employees notice that if ICE is going to conduct an inspection of your I-9s, that the employees will receive 72 hours notice. So on the notice form, it has to say, if we are subjected to an I-9 audit by ICE, we will be giving you notice that there is an I-9 audit going on at least 72 hours before the audit date. So that is really the way this law has been characterized in the media, is to know your rights about immigration enforcement. And that was really the main thrust of the legislation. So this is the second part of it. It needs to advise employees about protections against unfair immigration-related practices against employees exercising protected rights. So under California law, if employees, for instance, provide certain documents for their I-9 verification and the employer doesn't take those documents as valid and they don't have a good reason, that would interfere with employees' immigration rights. So the notices have to advise employees of the rights that they have under California law to be protected against unfair immigration practices. Also, interestingly, the notices have to advise employees of their rights to organize with a union or engage in protected activities. So this is an interesting thing going on right now, just as a side note. As you know, the federal government shut down, which means certain things having to do with labor unions that are administered by the National Labor Relations Board are also shut down. So California has stepped in and said, well, we're not going to rely on the federal government anymore. We are going to take the affirmative step of requiring employers to advise employees of their rights to unionization. And there's a whole thing that's going to be going on about whether or not this is preempted by federal law. You probably don't have to worry about that, but you do have to worry about the fact that your notices to employees have to have an advisement on rights to unionize and engage in protected activity. And lastly, and this goes back to the immigration piece, it has to advise employees of their rights under the Fourth and Fifth Amendments to the Constitution when they interact with law enforcement officers in the workplace. Okay, so this is really directed at if ICE agents show up. What are your rights as an employee in terms of illegal search and seizure and having an attorney and not waiving your rights to self-incrimination? So all of that has to be included in this notice to employees. And again, the template is supposed to show the model language for this. I wouldn't rely on that. You need to do your own research and figure out what your notice should look like. And then when the template comes out, if it does come out before January 1st, great, we can compare it and make sure that it's compliant. But if not, at least you've got something ready to go on that date. Another part of this legislation is that we are now, as employers, required to give notice to employees that they can let us know who their designated emergency contact is. And this has to do, once again, with immigration. If the employee notifies the employer that they would like their emergency contact notified in the event they're detained or arrested at the workplace, then the employer is obligated to then give notice to that emergency contact. So-and-so, your husband, your spouse, your child, whoever, has been detained or arrested here at the facility. So there is a requirement to give that notice if the arrest or detention is during work hours or if they're performing job duties. But if they're not at the work site when it happens, but they're on company business, you only have to notify the emergency contact if you have actual knowledge that they've actually been detained, right? If the first call from the employee is, hey, I'm out making a delivery and I've been pulled over and ICE is detaining me, now you have actual knowledge, you have to notify the emergency contact. So you must provide employees an opportunity to name their emergency contact by March 30th of next year or at the time of hire. So again, this is another form that we've got to give to employees to basically say, hey, if you want to let us know who your emergency contact is in case you're detained or arrested at work, please give us that information and we will notify that emergency contact if you're detained. So from a compliance standpoint, number one, with the notices, I think you have to have something like most of other HR forms where the employee acknowledges that they received and have read and have understand the notice. And secondly, that employees acknowledge that they have received notice of their ability to designate an emergency contact and that the employer has notified them of their rights to have that emergency contact notified in case of arrest or detention. So again, I know this really makes you happy. More paperwork. Isn't that great? But it's important to have this documented because the law specifically says you got to keep these records for 3 years. And if there is a violation, it's a penalty of $500 for each employee for the notices. So if you didn't send out the notices and you've got 10 employees and the labor commissioner shows up and says, where's the notices? Where's your proof that you gave notice? Well, we don't have that proof. Okay, I'm going to issue a penalty of $5,000. And then for the emergency contact, the penalties are even greater. It's $500 per day up to $10,000 per employee for failing to notify them of their rights to designate an emergency contact. So from a compliance perspective, we have to make sure that our paperwork's in order and that we store it for at least 3 years. Now, if it's paper and you digitize it and you store it electronically, that's fine. But there has to be something where if the labor commissioner shows up, and I've had this happen recently, the labor commissioner is now sending out their investigative teams to do random audits. And just out of the blue, companies are saying, hey, somebody's saying they're from the state labor commissioner showed up and they want to see all my documentation. So I expect that that's going to happen more frequently in the future, and they could show up anywhere. So it's, just because you're in the nonprofit world or a religious corporation, that doesn't insulate you from somebody from the labor commissioner just showing up because it looks like they're just pulling names out of a hat from what I've seen so far. So just be aware of that.